I am with the topic Constitutional Mechanisms for Enforcement of Human Rights. Introduction. On the introductory part, the Constitution of India is the supreme law of the land, which provides for the good governance of the country. It sets forth not only the constitutional apparatus, but also there are other special provisions for safeguarding the fundamental rights of its citizens. The fundamental rights are those rights enshrined in Part 3 of the Constitution, which gives de facto and a de jure recognition to the inalienable human rights. Human rights are the inherent and inalienable rights of all human beings, which consist of both civil and economic rights. The preamble of the Indian Constitution aims to build and realize socio-economic order where there will be social, economic and political justice and equality of status and opportunity for all. Human rights under the Constitution. The Constitution being the supreme law of the land, any law or rule made by the legislators or statutory authorities which is ultraviolates the Constitution is void. Apart from the fundamental rights, the directive principles of the state policy, which is enshrined in Part 4 of the Constitution, also lays down the provisions dealing with directives which obligate the state to make laws and policies by applying the directive principles to obtain and realize a welfare state. These directives are not enforceable, and for their alleged violations one cannot approach before the court. However, the Indian Supreme Court in a catena of cases held that the fundamental rights and the directive principles are to be harmoniously construed. The Constitution also lays down certain fundamental duties at Part 4A of the Constitution to be followed by the citizens, and these duties are made with an aim to obtain national integration, harmony and to maintain a good environmental condition for all. The very notional idea of accommodating the fundamental rights, which are nothing but the inherent human rights, is that every human life, no matter rich or poor, male or female, or children of any caste, creed, color or race, must be valued equally. Thus, India had legalized the human rights under the Constitution. The framers of the Indian Constitution manifestly incorporated the fundamental rights in the Constitution itself so as to enable every human being to live with dignity and develop their personality to the fullest. For the enforcement of these guaranteed human rights, the Supreme Court as well as the High Courts play a major role to enable to grant the rights to the individuals whenever and wherever such rights are infringed or violated. The state, being the guardian of its citizens, the duty to safeguard the rights of the citizens is cast on the government and its machineries. The Indian Constitution adopted a federal form of government where separation of powers amongst the executive, legislative and the judiciary is in the system. The reason behind this objective is that the three branches of the state may work in their respective realm without encroaching upon its other's boundary, and judiciary on top of all can review the acts of the government wherever and whenever it goes wrong. Therefore, for the achievement of the fundamental goals, The independence of the judiciary in its true sense is a necessity. Role of constitutional apparatus. The cause for frequent violation of human rights occur due to diversified forms of life. The national political situation is also one of the factors of such violation. The hunger for power by the Indian politicians and their dirty politics often found ingrained in the deprivation of rights of the individuals. Another factor for such violation is the traditionalism and the belief of the Indians towards certain groups such as women and children. The culture of inferiority of women from man. Various discrimination towards women in the name of tradition and culture have been heard. For instance, honor killings which are heard in various states across the country, news for commission of various forms of crimes against women, etc. Terrorism and armed conflict situation are again few important factors for human rights violations in various states of the country. Ethnic violations due to communalism and regionalism cannot be avoided, and there has been a series of human rights violations due to such. To prevent such violations of human rights, the state, being the guardian of the citizens, cannot be set free from its liability. The state is responsible for every human rights violation, as it is the duty of the state to maintain peace and tranquility in the society and to provide safeguard to life and the property of every citizen. According to Dicey, an eminent jurist who rightly put his word as abstract declaration of the rights of human beings are of little value unless there is a definite mechanism for enforcement of such rights may be remembered. The constitutional mechanisms which are mandated and responsible to act for the enforcement of human rights may be categorized into the following heads. 1. The legislature. 2. The executive. The legislature. It is the prerogative function of the legislature to make and unmake laws. The legislature, through its law-making process, can take adequate measures to promote and protect the rights and the freedoms of individuals. The legislature, both at the center and the states, have enacted a number of protective legislations, especially for protecting women and children's rights in India. Right of Children to Free and Compulsory Education Act 2009, Protection of Women from Domestic Violence Act 2005, Sexual Harassment of Women at Workplace Act, Prevention, Prohibition and Redressal Act 2013, the Protection of Children from Sexual Offences Act 2012, etc. may be mentioned. The executive. The administrative wing of the state also plays an important role in enforcing and implementing laws and policies, inter alia, protecting human rights of citizens and individuals. The executive acts as the backbone of the welfare state, like in India. In addition, the constitutional mandate that has been assigned for executive is found to be the foremost concern, especially for promotion and protection of human rights of individuals. The law enforcing agencies, being the vital part of the executive wing, are playing a predominant role in the criminal justice system of the country, which has virtually aimed to prevent and control crimes in the society. It also plays an important role for standing against human rights violation, for letting the citizens make available of redressal for the grievances which are within the meaning of human rights law. Some important works of the executive may be mentioned as that power of the executive having the legitimate mandate to set up commissions or committees in both national and state level. Now, the executive wing had successfully established the National Human Rights Commission and such other state commissions or committees, national commissions and committees for ACs and STs, minorities commissions, consumer forum and information commissions, etc. Next, role of judiciary. The Constitution of India is not a self-executing document. It is the duty of the courts to expand the true meaning and the concept of human rights as enshrined in the Constitution. For the enforcement of the guaranteed rights under Part 3 of the Constitution, the Constitution itself provides under Article 32 as right to constitutional remedies for approaching direct to the Supreme Court in case of infringement of the fundamental rights. Further, a similar remedy is available under Article 226 for approaching before the High Courts for violation of the fundamental rights guaranteed by the Constitution at its Part 3, as well as for violation of other constitutional provisions apart from the fundamental rights. The framers of the Indian Constitution made a remedial right under Article 32 of the Constitution a fundamental right in itself to approach before the Supreme Court for violation of the guaranteed rights. Further, the Constitution went to the extent of realizing the manner of judicial review by incorporating under Article 13 that the law which contravenes the fundamental rights shall be declared as void. To protect the individual rights, one may move the Supreme Court or the High Court of a state having competent jurisdiction for issuance of writ of any nature such as habeas corpus, mandamus, certiorari, prohibition and quo warranto, etc. The Constitution nowhere defines the writs. The writs which are issued by the Supreme Court of India and the High Courts are same to those prerogative writs issued by the Crown King in England. Judicial activism. Judicial activism has become one of the good source and an important lawmaking procedure where many facets of rights have been recognized today. In spite of the specified fundamental rights, the Supreme Court and High Courts, through writ jurisdiction, have been able to formulate legal principles of rights and liabilities of which the framers of the Indian Constitution could not have imagined that such would become a necessity for realizing the individual rights one day. Article 141 of the Constitution is the provision which literally grants the law-making power to the Supreme Court by way of providing that the law laid down by the Supreme Court becomes binding to all. Right to privacy. The Supreme Court in Gobind versus State of Madhya Pradesh, AIR 1975, Supreme Court 1378, held that right to privacy was assumed to be a part of personal liberty guaranteed by Article 21 of the Constitution, though the same is not explicitly provided in the Constitution. It is ingrained in the fundamental rights of life and personal liberty. Further, the Supreme Court in People's Union for Civil Liberties versus Union of India 1997 1 SCC 301, also found in AIR 1997 Supreme Court 568, unambiguously held that right to privacy was a right to life and personal liberty enshrined under Article 21 of the Constitution. And if once a fact is established as a case of infringement of right to privacy, provisions of Article 21 would be attracted and the right cannot be violated except according to procedures established by law. This case is also popularly known as phone tapping case, and held that telephone tapping is a serious invasion of an individual right to privacy and the same violates Article 21. In the present context, tapping of mobile phone of individual is largely used by the state authority in the name of identifying unlawful activities and to nab them. Here, it may be kept in mind that the concept of right to privacy requires to be developed and enlarged by the courts. Right to speedy trial. The International Covenant on Civil and Political Rights 1966, under its Article 9, provides that a person arrested or detained on a criminal charge shall be brought before a judge and shall be entitled to trial within reasonable time or to release. The Constitution does not provide a fundamental right for speedy trial without undue delay. However, the Supreme Court in Hussain Ara Khatun's case, which is reported in AIR 1976 Supreme Court 1360, held that though such right is not enumerated as a fundamental right, the right is implicit in its broad sweep and content of Article 21. In Munshi Singh Gautam and others versus State of MP, 2005 Krill Law Journal 320 Supreme Court, the apex court had been pleased to render its observation that the government and the legislature must give serious thought to the recommendation of the Law Commission in its 13th report as to amendments to the Evidence Act to curb custodial crime, and the courts must have to change their outlook, approach, appreciation and attitude, particularly in cases involving custodial crimes, and they should exhibit more sensitivity and adopt a realistic approach rather than a narrow technical approach, so that the victim of the crime has the satisfaction that ultimately the majesty of law has prevailed. Conclusion. In spite of the mechanisms provided by the Constitution and after so many years of its independence, it is high time to find out how the country has been progressing towards the objectives of the Constitution. Whether India can be one of those countries who could be proud of maintaining the basic structure of the Constitution as envisaged by the Constitution. The major factors for violation of human rights also can be curtailed through education to all the citizens by making them understand more about their rights, duties and the meaning of welfare state, which are well manifested at Part 3, 4 and 4A of the Constitution.